Earlier in December, Pakistan's Supreme Court endorsed the revival of the Reko Diq project, and the government moved lightning speed to get the Foreign Investment Promotion and Protection Bill 2022 fly through the parliament to pave way for the $9 billion deal. It's no wonder they were in a hurry. It's the biggest investment deal in Pakistan's history. Unfortunately, for the ruling coalition, their allies are not that happy and even threatening to quit government over the deal. If you're thinking why such a huge investment is garnering mixed feeling, here's why. To understand the present, we need to go back to the past, and we mean way back, the early 1990s. That's when Pakistan's biggest gold and copper reserves were discovered in Balochistan's Shagai district. The reserves are known as Reko Diq. Now, Pakistan wanted to explore these reserves but lacked the expertise. And that's when international firms Barrick Gold Company and Antofagasta entered the picture. They are world-class mining companies. The agreement they signed with Pakistan government is known as Chagai Hills Exploration Joint Venture Agreement. Over the next 18 years, these firms spent about $240 million in mineral exploration and feasibility studies. By 2011, they confirmed presence of commercial level gold and copper reserves and asked Balochistan's Mines and Minerals Development Department for an extension in mining lease. A quick update. By then, the Pakistan People's Party government had introduced 18th Amendment giving provinces the right to decide mines and mineral development. Coming back to the request, the provincial government turned it down. These mining companies spent nearly $250 million and there was no way they were going to let this go. So they challenged the decision. They sued Pakistan at International Center for Settlement of Investment Disputes for specific performance in extension of mining lease, while Balochistan government was taken to the International Court of Arbitration. The ICSID decided the matter against Pakistan, fulfilling all demands of investor companies. Here's when things got even more complicated. In January 2013, the Supreme Court of Pakistan declared Chagai Hill Exploration Joint Venture Agreement illegal and null and void. Zahid Ibrahim will break it down for us.
This was originally a petition filed in the Balochistan High Court in 2007, and the decision of the Balochistan High Court was that this agreement for exploration license was entirely in accordance with the law. The Balochistan government at that time supported the agreement also, and the Balochistan High Court dismissed the petition. But when the matter went to the Supreme Court, the Supreme Court took a slightly different view, because the Balochistan government at that time, in the middle of the case, completely changed its stance. It says that, well, now all the documents have come on record which show that this agreement with Tethyan was not in accordance with law, and therefore the Balochistan government was seeking to oppose it. During the course of the hearings, in fact, the mining lease which was sought by the company was denied by the Balochistan government. And the Supreme Court's 2013 decision, the Maulvi Abdul Haq case, which is known as, basically sanctioned that decision of the Balochistan government in denying the lease. And what the Supreme Court did was that it went further and it held that the original agreement, which was dated as far back as 1993 for the exploration and joint venture, was held to be illegal.
The Supreme Court's decision made the investor companies file yet another lawsuit against Pakistan with the ICSID, which in 2019 announced a $6.927 billion award against Pakistan for violating the agreement. Meanwhile, the ICA also ruled against Balochistan government. Although the penalty is yet to be announced, legal experts expect it to be around $3 billion. And that would bring the total amount that Pakistan is liable to pay to $10 billion. After the $6.9 billion penalty was imposed, Pakistan successfully negotiated a new Reko Diq deal with the Barrick Gold Company. And the Argentinian firm Antofagasta agreed for a $900 million settlement to exit. Once the agreement is signed, the $10 billion liability will be waived off. By this time, Barrick Gold Company is not taking any chances and has set forth some conditions. For starters, it wants the top court to endorse the agreement to avoid it being declared null and void like it did in 2013. It has also asked for federal and provincial legislative cover for foreign investment and protection of exemptions provided to foreign investors. And Pakistan had until December 15 to get the green light on both those terms. Consequently, a presidential reference was filed on which the apex declared the revival Reko Diq project legal, following which the parliament also passed the legislation. Now that we know what happened, let's talk about the new deal. Under the new agreement, Barrick Gold owns 50% of Reko Diq, 25% is owned by 3 federal state-owned enterprises, and 15 and 10% by Balochistan on a fully funded basis and free carried basis. For more on the deal, we've got some expert opinion as well.
You had the foreign investor trying to recover through making claims on Pakistan's assets abroad. If you remember, the Roosevelt Hotel was also initially attached by that foreign investor, but also and on the sidelines as far back as 2016, negotiations were being held for an amicable settlement, and they went through various phases, and ultimately earlier this year an agreement was made by the 2 foreign investors with the government of Pakistan on amicably resolving this matter. One of the foreign investor, which was Augusta, was going to be paid $900 million and they would walk out, and in exchange Barrick, the other company, they would in fact continue and be granted a new exploration and mining lease by the government of Balochistan, and in exchange Barrick would be 50% shareholder in a new joint venture in which the government of Pakistan through its state-owned entities would have 25% interest, the government of Balochistan would have 25% interest, and out of that 25%, notably 10% was free, so that the government of Balochistan would not have to pay anything for that 10% interest in this joint venture. But part of the agreement, as you can well imagine, because the foreign investor had earlier suffered, and this time I think this was one of the preconditions for the settlement, because they did not want to have another settlement agreement with the government of Balochistan or the government of Pakistan, which would ultimately then, after a few months or years even, be challenged on some ground or the other. So this time they wanted an assurance that the government, whatever agreement that they have signed on, will actually live by those agreements, and the foreign investor would be able to realize the negotiated settlement that had been arrived at. That was the reason that ultimately then the president had to make a reference to the Supreme Court and ask the Supreme Court a very straightforward but pointed question, that whether these settlement agreements could be arrived at in view of the original 2013 Reko Diq judgment. And the Supreme Court answered that question in the affirmative, saying that yes, there is prima facie no reason or no legal basis why the government of Pakistan cannot enter into these agreements.
This is Ibad Ali Shah signing off for Dawn News English.